the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Greetings, everyone. Welcome back to Case Files, the podcast where we analyze real fair housing cases to help property management professionals stay compliant and protect their communities. I'm Jonathan Sarr, and joining me again is fair housing attorney Leslie Tucker. Welcome, Leslie.
Thanks, Jonathan. This case centers around a very common topic, ESA verification, that causes a lot of confusion for many of you out there, I know.
Exactly. Out of all the episodes that we record, emotional support animals are one of the hottest topics. And today's case is United States versus Greenbrier Partners LLC. And it revolves around a graduate student who sought to have an emotional support animal in her apartment, but was allegedly denied that right. What makes this case even more relevant today is how online healthcare and licensing across state lines comes into play. So Leslie, let's dive in. What are your thoughts?
According to the complaint, Sarah Williams, who is a 27-year-old doctoral student at Florida State University, she had recently relocated to Tallahassee from out of state. She signed a lease with the defendant's apartment complex, and which is a student housing community.
Mm-hmm. Yep.
And the community has a no pets policy.
Got it. So why did Sarah decide to obtain an ESA?
The complaint states that Sarah has long-standing mental health issues, diagnoses including PTSD, anxiety, and depression. She had been receiving treatment and medication for these conditions for a very long time, since childhood. But moving to a different state meant that she had no support system anymore in her new home. So when she decided to obtain an ESA, which was about 2 months after moving to Florida, she had not yet established care with a local mental health professional.
Okay. So her existing doctor, someone allegedly familiar with her condition, wasn't licensed in Florida?
Correct. This was in her home state, where her her therapist was licensed. The complaint states that her previous therapist supported her need for an ESA and reportedly would have provided a letter, but she was not licensed to practice in Florida. So because of this, Sarah didn't think that she could ask her previous provider for a verification letter.
That's a very interesting situation. So, and that's where the online provider, now that's where they come into this picture?
Correct. The complaint explains that Sarah sought out information online, as so many people do, and was connected through a website to a licensed mental health counselor, someone who's based in Arkansas, but licensed in Florida. So after reviewing her history that she provided on the website and conducting a phone consultation with her, this mental health counselor provided a letter recommending that she be allowed to keep an ESA dog.
Okay. So are tenants permitted to obtain verifications through these ESA websites like Sarah did? Is this considered to be legitimate?
That's a very big and difficult question to answer, admittedly. So I'll just say this. So is a therapist who provides services via telehealth or other digital methods, are they capable of being a reliable verifier? Yes, absolutely they are. And neither the Federal Fair Housing Act nor HUD requires that the provider be licensed in the same state as the property. By the way, I do acknowledge that there are some state statutes out there that do require that, but the Federal Fair Housing Act does not. So the question is, whether the provider has actually provided services to the tenant that gives them personal knowledge of the tenant's disability and their needs. While I believe that HUD guidance has discredited practices such as online questionnaires and brief one-time phone consultations, which may have been involved in this instance, the sufficiency or reliability of Sarah's particular verification really isn't an issue in this case.
Okay. So what happened after she submitted the letter to her housing provider?
According to the complaint, her request was denied 2 days later. The denial cites reasons, many reasons actually, some being that it would be a financial burden, it would be an operational disruption, employee safety, the possibility of a health and safety risk, insurance liability, and the list, goes on. There was also a warning that her lease could be terminated for allegedly falsifying information on her rental application that indicated she didn't have an animal.
Well, that sounds harsh, especially since, as the complaint says, she didn't even have the dog yet. So she was just asking for approval.
Right. The complaint emphasizes the fact that Sarah only intended to adopt a dog if she was granted permission. She did not have it yet. So there were allegedly no follow-up questions or any follow-up correspondence from the defendants about this request. It was just simply denied.
Wow. Okay. So can a housing provider claim undue financial burden or operational disruption when denying an assistance animal? Is that a valid defense?
Generally, no. While these can potentially be reasons that other types of reasonable accommodation or modification requests could be denied, assistance animals really don't fall into either of those categories. If an assistance animal is verified to be necessary for someone's disability, it's generally considered to be reasonable, just sort of across the board. Also, unless there's information about some, negative prior incident involving that specific animal, it's never legally justifiable to deny an ESA request based on the concern that they might be a safety risk.
Got it. So what about the source of Sarah's verification? Could they have denied it on that basis?
Well, the source ultimately wasn't cited by the defendants as part of the reason for the denial. But could they have denied the request due to it being unreliable? I can't answer the question really without kind of knowing a lot more details about the case. But as a best practice, if a housing provider believes that a verification was written by someone without personal knowledge, the resident should always be given another opportunity to provide reliable verification. So an immediate denial is never recommended, even if the initial verification is suspect. And also, an out-of-state provider shouldn't be a reason for denial either.
Okay, got it. So what happened to Sarah?
Well, according to the complaint, she ended up not adopting the dog, obviously, and instead moved out of her unit early. She did continue to pay rent at her place, but she moved into a different unit with roommates. And her new place did allow animals. Her roommates had pets that she was able to interact with regularly. And the complaint says that this had a very positive impact on her well-being and did help her reduce dependence on medication.
Interesting. Fascinating. A powerful reminder of the real life consequences behind these types of legal disputes.
Yes, definitely. This case hasn't been decided yet, but it does offer, I think, a valuable lesson about how to approach accommodation requests, especially for tenants who are new to the area, maybe relying on telehealth and kind of navigating life transitions.
Yeah. Yeah. And our audience is eating this up. So thank you so much, Leslie. Thanks to our audience. Thank you for being here. If you are a housing provider, remember how you respond to accommodation requests matters. Be informed, stay compliant, and always consider the human impact.
Well said, Jonathan. Until next time, everyone, stay away, stay aware, stay fair, and stay responsive.
Take care, everyone.